All rise. The Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. Good afternoon. There we go. We are here today on our case number 1CA CR16 0759 and 0785, State of Arizona versus TAGGE. So, counsel, as you know, each side's allotted 20 minutes for your argument. The appellants may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself because the clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful if you would recite your name and the name of your clients for us. We have studied the briefs of the parties and closely reviewed the record. We've also discussed the case in our conference together, so you can keep that in mind when you present your argument. With that, you may proceed.
Nick Pachadlik for the appellant Matthew TAGGE. Also here is Sherry Lauritano for Elena TAGGE, the co-defendant below. Ms. Lauritano has graciously given me the time for oral argument, but is available in case the court would like to interrupt and have me sit down, have her stand up. I'd like first to raise a point about plain language and then turn to the issue that the court raised on its own about the Department of Health Services regulations concerning the Arizona Medical Marijuana Act. And my argument, of course, is that Mr. Matthew TAGGE was immune from arrest, prosecution, and all other penalties, as was his wife. His convictions should be vacated, as well as those of his wife. If ever there was a phrase susceptible to plain language, this is not it. We have in front of us at least 6 different official interpretations of the words public place. We have the Department of Health Services, as the court observed. We have the Smoke-Free Arizona Act, our only statutory guidance on the meaning of smoking and public place. We have the trial court's plain language meaning from a dictionary as meaning open to view. We have the state on appeal with their own plain language meaning from a dictionary meaning something else. We have Whitaker, this case heavily relied on by the state, where the court delved deeply into common law and history to conclude that a man's private living room in his residence was a public place.
Could I ask you, if this were not a vehicle, a car, and if someone were just standing in the parking lot, would you agree that it's a public place?
No.
Well, would you agree that there's no immunity?
No. There is immunity because they were using marijuana, and if they were and they were smoking marijuana, but they weren't doing so in a public place, even if they were outside of their vehicle. You had to pay $10 to enter the parking lot. It was not open to the public. We could look.
Even if you go like to the zoo, that's not a public place? It's okay then? You don't. You still have immunity you can smoke marijuana at the zoo?
The zoo wouldn't allow you to, I'm sure, as this Court of Appeals recently held in Maestas, which was the case where the legislature tried to criminalize the possession of marijuana on a college campus. As that opinion said, the legislature can't thwart the goal of the statute, but the government is a property owner, and the government can regulate what can be allowed on its property, disallow marijuana, and trespass anybody who does bring it onto a college campus.
I'm not talking about a government-owned property, but would you not view a privately owned zoo, is that not a public place? If it's open to the public, you might have to pay $5, but is that not, in your view, that would not qualify as a public place?
No. To quote State's brief, page 20, words have different meanings in different contexts. And right here, we're talking not just about public place in the abstract. We're talking about it in two lines, two subsections of the Arizona Medical Marijuana Act, which distinguishes between public place and public transportation.
So in your view, the car really isn't the key to this analysis. It's just a parking lot where you've had to pay money. That means it's not a public place.
Well, there's two barriers, and those are both barriers. No, a paid-for parking lot is not, nor is
What about
the
a free
car.
parking lot?
A free parking lot would be.
I mean, if you're in a car in a free parking lot, is that a public place?
No, a car is not public. We can look to Arizona's laws. If somebody tries to enter my occupied vehicle under our justification defenses, I could shoot them dead just as if it was my residence. Arizonans fiercely care about their privacy in their private places. We see that in our law regarding privacy in homes. We have that. We also see that in our other laws saying that a person can't be charged with DUI, DWI if they're in their vehicle, because even though the vehicle might be in a public place, a highway, it's turned into a temporary shelter.
But does it turn it into someplace other than the place where it's parked? If for example, you park your car on my front lawn and I have a no trespassing sign on my front lawn, isn't your car in my yard? Even though you might be in your car, but aren't you also in my yard?
Yes, absolutely, but I'm not in a public place. You can look at the laws of Ohio, Iowa, West Virginia, Alabama, even Arizona. When we talk about things like DUI, DWI in public places, there's an exception for vehicles. You can't be publicly intoxicated if you're sitting inside your car. You're not driving under the influence if you're sitting in your car. The Fourth Amendment says not anybody can enter your car because it's a private place, not a public place. Now, looking at this specifically, I want to talk about the state's probably best case, Carlton from Michigan. And the Michigan court addressed somebody smoking marijuana in his car, medical marijuana, protected under their Medical Marijuana Act. It was in a casino parking lot that there was no, you didn't have to pay to get into. And the Michigan court said that that was in a public place. And I want to talk about what Carlton doesn't address. Well, number one, it doesn't address a paid parking lot. They recognized a difference between a public parking lot and a parking lot you had to pay to get into.
I don't mean to take you off the case for too long, but I'm a little troubled by this notion that anytime you pay to get into some place, you're no longer in a public place. Does that mean that you can freely smoke walking around the Phoenix Zoo that you paid in for, or in a movie theater that you paid to get into?
Well, under the Smoke-Free Arizona Act, you're not allowed to smoke in an enclosed place like a movie theater. And so that wouldn't be allowed. And as this court said in Maestis, the Arizona Medical Marijuana Act is intended to protect these people. There are other laws, and the Medical Marijuana Act itself allows landowners, like the city of Phoenix or the state of Arizona, to make rules about what can be done on their land.
So if you're at an outdoor concert venue and you've paid $150 to get in to see a show, and the venue doesn't really care, you're immune for smoking sitting in your seat right next to your fellow concert goers.
Well, I'll say number one, that's not what the Taggies were doing. They were in their lock-tinted car.
That response to hypothetical questions always befuddles me, because obviously it's a hypothetical question. We know the facts of the case. So take it as a hypothetical.
If it's the venue's privately leased property, the venue can make the rules for smoking. People may smoke tobacco, but the smoking of marijuana has been declared by the people of Arizona to have a history of 5,000 years, to have been prescribed by thousands of physicians to over 260,000 patients to be medicine.
Is that a yes?
Yes, it's a yes.
Okay.
If a person can inject insulin in this place, they can medicate themselves because they have a qualifying condition, and the people of Arizona have said this is a painkiller. They could be there.
They've said you can take it in any form that you want, except that you don't have immunity if you're smoking it in a public place. So if you're at the concert and you want to consume it in some other manner, isn't that what seems to be contemplated by by the statute?
It does, although at the time that this happened with the Taggies, the Maricopa County Attorney's Office would prosecute you for using edibles.
Right, but we're not them.
That's true.
So, I mean, it seems like there are two ways of resolving this case. One is the way that you're suggesting now, which is to decide whether a paid-for parking lot is a public place or a private place. And the second would be, well, let's look at the car. Does the location of the form of transportation determine whether one may smoke, whether one is immune for smoking in the form of transportation, or does the form of transportation itself determine whether one is immune?
Well, I want to say the answer to that has been touched on by the panel. It regulates smoking and only smoking in a public place. Why? There's an absurdity here if we're going to say that a person can go around, mainline, inject, swallow, eat, rub, puff with a vaporizer, marijuana, and we're going to say that we should make a broad exception for people who smoke. This informs what the voters intended by saying you can't smoke in a public place. They didn't mean to blow it open and distinguish between puffing with a vaporizer or smoking marijuana, because that's senseless. And that should inform whether we treat the car as a public place or the parking lot as a public place. Only the Smoke-Free Arizona Act addresses this unique difference. Smoking in a public place as opposed to using, injecting, mainlining, vaporizing, all these other things, being under the influence, just like if you're taking the painkillers that your doctor prescribed for you. And this doesn't resolve the statutory language. This is prohibited on public transportation. The voters didn't say transportation, they said public transportation. If you go with this theory that private transportation is a public place, it blows away those words in the statute. It erases them. The voters could have said transportation.
I wonder about that, because if the Act didn't say public transportation, would anybody seriously make the argument that a city bus is not a public place?
No. And that's
so is the public transportation language superfluous?
It is not. It tells us there's a difference between transportation and places. Otherwise, a city bus would always be a public place. But the voters said, no, we're drawing a difference between those two things. And that means there has to be a difference between smoking on a public bus, which is enclosed, which would be forbidden by the Smoke-Free Arizona Act, and smoking in a public place.
What about a Greyhound bus? Is that public transportation?
Yes, I believe it's a common carrier. We could get into property law, which...
What about an Uber?
And the question goes to when the bus is parked, is it still public transportation? An Uber car, first, in your view, is Uber public transportation?
We're getting into regulatory law, but yes, in my opinion, Uber, buses, stopped or not, trains, all these things are public transportation.
Well, so then couldn't there be a difference? The language isn't necessarily superfluous if the statute means that you don't have immunity for smoking in a car that's used for as an Uber, but you do have immunity if you're in your own car, in your own garage, you have immunity.
Exactly.
Okay, but so that means it's not superfluous. It would still mean that you can't smoke in an Uber, even though you're in your own garage. It's public transportation, and you're about to leave to pick someone up. So can't we read the statute to mean that you cannot smoke in the Uber, in the vehicle that's going to be used to pick up someone?
If it's parked in your car, in your garage?
If it's parked in your garage, that is tricky, and it's not an issue I can answer. But what we take from this is that the voters distinguished public transportation and transportation from place. Where that takes us is that private transportation is different. And even if we look at all these different definitions, if we were the Michigan court and we were looking for law for a privately owned parking lot that you had to pay to get into, where would we look? We might look at Strider, the California case that was cited by the state. In Strider, the California case goes through pages and pages struggling with the meaning of public place. And in Strider, the court said, well, the only commonality that we're finding with these cases is that it's public if you can enter without challenge. Now, nobody can enter a paid-for parking lot without challenge. The officers at trial said as much. And you certainly can't enter somebody's occupied vehicle without challenge. In Arizona, voters, if the legislature said you could shoot them. Finally, there is a common sense argument here.
Enter a parking lot, the public, isn't it more, couldn't you say that you can't leave the parking lot without paying? Isn't that, can anyone walk through a parking lot if it's just an open lot that somebody's there parking for a concert? The public can walk through, but you might not be able to pull your car out unless you've paid. Would that be an accurate description of how a parking lot works?
No. If it's a paid-for parking lot, you have to pay to get into it. If they find you trespassing between the parked cars, they might think that you're trying to rob somebody. So, although usually nothing's going to happen, if security wanted to trespass you, they certainly could because you didn't pay to get in.
Unless you're at a concert, though, most parking lots have you pay on exit.
Hasn't been my experience. I come from Detroit. They certainly take your money up front there.
Well, try parking downtown at any one of the major buildings or at the airport or in such parking lots, you go in, you take a tag, and then you pay to leave. But the public is free to enter those spaces on foot or in a vehicle. Wouldn't you agree with that?
It's a license. You're only allowed in there if you're agreeing to pay when you get out.
What if you walk in on foot and never try to park?
You're trespassing. They usually have signs saying you're not supposed to walk around those areas. If you did try to leave your car there, they would tow it. You would have abandoned it, and you'd have to pay to get it out of a lot. So there's also a common sense issue here. Somebody wants to take insulin, and they're at one of these concerts. They're going to go to their car. They want to breastfeed their car. They want to take oxygen because they have problems with that. They're going to go to their car because that is a place of privacy. The same. Okay, and I want to reserve some time, but as far as the Department of Health Services definition goes, I think we can start. Well, the place to start is the TAGGE's vehicle falls under the definition of a private, a non-public place, because the TAGGE's vehicle is a location intended for the regular exclusive use of the TAGGEs. You could also make the same argument for the parking lot. That's only intended for their invitees, which AMA anticipates that a property owner will be able to allow its invitees to smoke marijuana there. We look in 362814 describing how property owners can allow or disallow the use of marijuana. But we can start and stop at 362803C because 2803C says the department is authorized to adopt the rules set forth in subsections A and B. And the rules set forth in subsections A and B are narrow. They are unimpressive grants of power. They allow DHS to regulate the manner of adding conditions for medical marijuana, regulate what the applications will look like, manner of considering the applications, the fees they'll be collected, rules for making sure nobody steals the marijuana from dispensaries. So the Department of Health Services had no power to define what a public place is, and I cited cases in my supplemental authorities that speak to this, especially the Loftus case, which says that a law is something that regulates future conduct and fixes rights and duties. That's not a rule, and they struck down a rule that pretended to do that. And that's exactly what the Department of Health Services has done here. And I'd like to reserve the rest of my time if I could.
Sure.
Thank you.
Good afternoon, Your Honors. My name is Terry Christ, representing the state of Arizona. May it please the court. The enclosed area definition that defendants propose would allow smoking medical marijuana basically anywhere outdoors, sidewalks, public parks, squares, and that simply isn't what the electors would have intended through the use of the term public place. Public place has a plain and unambiguous meaning, as this court has already recognized in the Whitaker case, and that plain meaning includes automobiles located on parking lots. So I think the best roadmap really to start with is indeed the Carlton case. The facts are virtually identical with the one exception of the lot being pay versus free, although we don't think that really has much of a difference in terms of the outcome. But otherwise, Carlton's facts are nearly identical to the case here, and the layout of the medical marijuana statute is pretty similar too. It makes the same distinctions between transportation and a broader area where you can use rather than smoke marijuana, and yet that court came to the same conclusions that we're advocating here.
The problem I have with the Carlton case, I mean, I have read the Carlton case more than a dozen times, and I continue to be puzzled about the paragraph that is at the bottom of page 351 and the top of 352. I'll read the exact language, which I think turns good logic on its upside down. If the electors understood the term place, as used in the phrase any public place, to include the interior of vehicles, there would have been no need to separately exclude smoking on any form of public transportation, because smoking marijuana on public transportation wouldn't necessarily constitute smoking marijuana in a public place. That is precisely the argument that the defendants are making here, which is to read meaning into the phrase public transportation, which is in the Michigan statute. You have to understand that what is relevant is the car, not where the car is parked.
I think the best way of understanding the distinction between transportation and place is to see that they're actually separate categories. And so I think what the legislation is doing is saying that places and transportation are different things. So a car is a form of transportation. It's not a place. It simply takes on the character of wherever it's located. So
But what about the inference that we could, can't we draw from the statute's reference to public transportation the inference that that is distinct from private transportation, which is generally immune?
I think you can do that within subparagraph 1. But then you have subparagraph 2, which talks about public places, and I think the two are additive. You can't smoke marijuana if either you have public transportation or you have a public place. So the expression of one is the exclusion of the other within the particular sentence, but not as regards to the other category.
Well, how could your brief includes a hypothetical about a bus person, smoking in the private city garage on the bus before taking the bus out to. Is that the best you've been able to come up with in terms of how that provision could be applied?
No, I think we can do better. I've actually had quite a bit of time to think about this since then.
It's an interesting question.
It is, absolutely. I actually have two responses to that, and one is to engage that question on its terms. And I think there are a variety of forms of public transportation, including Greyhound buses, trains, etc. And especially with trains, it's not always easy to know whether you're on some kind of easement for private property, whether you're on state-owned land. It's not always clear. That obviously is also true with Greyhound buses, Ubers, whatever you want to consider public transportation. And I think the point is electors are wanting to cover their bases. So in addition to anything we might call a public place, we also want to make sure that we have all public transportation, regardless of whether it comes down to a place or not. I think the other thing that might be going on here is it somewhat changes the character of what the state needs to prove when showing the lack of immunity. So if indeed our construction is true and the transportation, or the car, the vehicle, whatever it is, isn't the place is the piece of ground it's located on, the state would have to prove beyond a reasonable doubt exactly where a bus was at the moment they showed the person-elect immunity. Well, that isn't the case if you also say, well, all forms of public transportation are included too.
Why not just say all forms of transportation? Why did they use the word public?
I think if you had a form of private transportation that was also on private property, say your car parked on your own driveway, you would have immunity. So part of what I think is going on here is what the Carleton Court recognized, which is all of these distinctions are kind of being made as balancing. So you're balancing the public's desire to allow the medicinal use of marijuana with the public's also desire to continue to keep recreational marijuana and the stigma attached to recreational marijuana illegal. So a lot of these distinctions, I think, are sort of in the balance of that in compromise. So why do we allow one thing and not other?
You think we should interpret this statute by inferring that the voters intended to create a stigma?
Well, all criminal law creates a stigma. So anytime...
A law. The AMMA is not a criminal law.
This is true, but the AMMA is also deciding which things to immunize. So the AMMA did not immunize all marijuana use. It only immunized medical marijuana.
So let me ask you this. Is an enclosed bathroom with the door closed a public place or a private place?
It's a public place. In fact, the Carleton Court addresses the exact question.
Bathroom is a public place.
A bathroom is a public place if it's in a public building, a building anyone could go into. And in fact,
that reasoning could get you into trouble in other cases, couldn't it? I mean, if you wouldn't really want the Court of Appeals to issue an opinion saying that bathrooms are public places.
I think the context matters. So within the context of the AMMA, and perhaps within the plain meaning of the term public place, they would be. But
Let's talk plain meaning. In my frame of reference, and perhaps I'm just strange, but I consider a bathroom to be a very private place. Are you saying you disagree with that?
I would argue that a bathroom in a public building is part of the public place. And
Say in a public building.
well, then I think it matters whether the building is public or private as to whether the bathroom
What if
is
it's
public
not
or
in a
private.
building? What if the bathroom is a standalone structure?
If the bathroom is a standalone structure, I think there's a better argument to be made it's a private place.
Okay, so if it's a standalone structure, then on a privately owned construction site, would you agree that it's a private place?
I think we could go there, yes.
Okay. And if we then put that standalone bathroom on a trailer and bring it to this concert parking lot for an evening, have we transformed its character?
I think the bathroom will take on the character of wherever it's in the same way that maybe a car or anything else would, which is the private place. It's private because it was on the private.
But then the statute's very oddly written, because if all that matters is the nature of the land, then why do we even talk about public transportation? Why not simply say land accessible to the public, a place accessible to the public, and make it easy? Instead, we have these narrowing terms in the statute that we cannot read as superfluous.
I think the role of the transportation section is doing at least two things. And one is to cover the bases. If you can have an instance where you have transportation that's public on private land, we still don't want immunity there, because in that one sense, we do care about the transportation. But also, we don't want to make the state have to prove exactly where the public transportation is located at the exact moment that the arrest is made.
So in your view, if it's public transportation, if you're viewing Greyhound bus as public transportation, if the bus is in Greyhound's repair shop, is that public transportation, and there would be no immunity for smoking on the Greyhound bus at that point?
Correct. All you have to do to lose your immunity is for either of these conditions to be met. Either you are in a public place or you are on public transportation. They're additive. They're not exclusive to each other.
In this situation where the language of the statute is not entirely clear, we can use other means of interpretation. One would be to try to discern the purpose of the statute. And there's the dichotomy that the statute draws between the immunity for using marijuana, which is much broader in terms of location than the immunity for smoking marijuana, is interesting. One might infer from that the purpose of the statute is to protect the public from secondhand marijuana smoke. Now, I'm not sure we're willing to adopt the defendant's notion that the Smoke-Free Arizona Act just applies a wholesale, but would you agree that we could look to that purpose, in other words, to protect the public from secondhand marijuana smoke in interpreting the statute?
I think it's certainly one of the things that could be going on with the statute. I don't think it's the only one. I think it's instructive that in all of the ballot literature that I came across, not a single reference was made to secondhand smoke of any sort. That distinction is never drawn overtly. The distinction I continue to see drawn in all of the material surrounding the enactment of this is that balance between medical and recreational use. And as I was saying earlier, all criminal law attaches with it a stigma. And there is still no immunity for recreational marijuana use.
Going back to the statute, though, what's the purpose between distinguishing between non-smoking use and smoking use?
Smoking is more open and obvious. I think that's part of what's going on. So one might reasonably think that observing someone smoking marijuana of any form is likely to decrease the stigma for all marijuana use, both medical and recreational.
Oh.
So I think, again, I don't think these are overriding as the only single purpose. I think there's multiple purposes going on, and this is a balancing act. I think secondhand smoke probably is playing some role here, but it's not playing the only role, because if it were, then the Arizona electors would have done the same thing the California and the Washington electors did and expressly incorporate their secondhand smoke statutes, and we didn't do that. I think that's significant. Why didn't we do that?
I'm not sure. philosophically, I'm not sure I can agree that it's significant or that we should be attempting to divine the intent of voters from atmospheric considerations. I think that's dangerous enough with a legislature that only has 90 people in it. It's much more dangerous with millions. I prefer to resort to the text. I look at what the legislature or the voters passed. And what they passed here contains a term, public place, that we've been discussing now for the last half hour or so. And we've, between the five of us, have come up with a number of different interpretations. If that term is ambiguous, then why wouldn't the rule of lenity apply?
The rule of lenity doesn't apply only when a statute is ambiguous. It has to be worse than that. It has to be, not only do we think the statute is ambiguous, but all of our attempts to resolve that ambiguity have failed. And that's why courts have referred to it as a rule of last resort. And I don't think we're there in this case.
What does it mean to fail? I mean, we can all resolve an ambiguity somehow. But if you have different maxims of construction that lead you to different conclusions, are you successfully resolving the ambiguity, or are you simply picking a result?
I don't think we're at the point where all the tools of statutory construction leave us uncertain as to what to do. I think it's also instructive that in the Whitaker case, this court made the point that the definition of public places open to the public was the plain and ordinary meaning. And the way I think about this is you have a plain and ordinary meaning, which, unless you have context to think otherwise, is the default application of the term, and then maybe in a certain context you might apply it different. That's exactly what happened in Whitaker. Whitaker made the point.
Well, okay, I don't mean to distract you from Whitaker, but to save time, would you say then that the character of the land is dispositive? That whether land is publicly or privately accessible is the end of the inquiry?
I think what's dispositive is whether the land or the place is open to the public. So I don't know if it matters who owns it.
Well,
in this
okay,
case,
open for traversing, in other words, open for physical presence.
if it's open to the public such that any member of the public could be there.
Okay, so if one has a home, and Arizona certainly recognizes the sanctity of a home, that abuts a public gathering, and one stands 2 inches from the edge of the property line on one's own home and smokes marijuana with a card on that private property, does the person have immunity?
If they're on their private property, they have immunity.
Even though the smoke is blowing into the public space?
Yes. And I think that's part of how we know secondhand smoke can't be the only thing going on here. Because if all we cared about was secondhand smoke, then you might say that we wouldn't let people smoke even on their own land if that secondhand smoke were likely to be smelt or ingested by someone else.
With your stigma argument, then, you can have a person proclaiming the joys of smoking medical marijuana, blowing it at the public as they walk by, but because they hold title to the 2 inches of land they're standing on, that confers immunity. That doesn't seem to fit with your social stigma theory at all.
It's a balance. So none of these purposes are achieved to the fullest extent possible. The electors are also concerned with making sure that people actually can use medical marijuana. And so to the extent to which those things conflict, they have to make a choice. And in some contexts, they've decided to allow more use of medical marijuana, such as when it's your own land. And in some contexts, they've allowed to minimize the use of medical marijuana, such as when it's a public place. So clearly...
And we haven't had a chance yet to address your colleague's suggestion that a car is anything but a public place because you're allowed to shoot someone who tries to enter. That point isn't entirely without merit, is it?
I think the Arizona cases that have looked at this would suggest otherwise. We have the Castellano case, which is in an open package container law context, which...
Under a different statute.
Under a different statute, but the case there seem to suggest that's the ordinary meaning of public place. That wasn't something specific to the context.
I'm sorry for interrupting, but the problem is the statute in that case especially provided that the ban would apply on a public thoroughfare. And public thoroughfare implies a car. You don't walk on a thoroughfare necessarily. You normally drive. So I'm not persuaded by that case.
Well, Castellano, the statute said public place or thoroughfare. And the court said that we find this would be a public place or thoroughfare. It actually found both in the holding.
The fact that this law doesn't say public place or thoroughfare, though, I assume wouldn't mean that the immunity extends to streets, right? Public place in this statute, you must read more broadly than in Title IV.
That's probably true. If the definition is indeed, as Whitaker suggests, and it's a place open to the general public, that would include streets. That would include parking lots, parks, anywhere outdoors where people are allowed to be. I think the other problem with treating a car as a place is it doesn't really comport with just a general meaning of the term. Most of the time when you ask someone what place they were at, they don't say my car. They tell you where their car went. That would be an odd use of the language. And again, they were clearly capable of...
Have you never received a phone call and somebody asked you, where are you? I'm in my car.
I mean, it's also true that if someone's driving from one place to another, maybe a cross-country trip, and you say, where do you go? What place were you at? They wouldn't answer my car.
No, but I'm merely suggesting that the plain language meaning of place could well include a car.
Or maybe it's, you just don't look to the place. I mean, it's a withdrawal of immunity statute. So you generally are immune if you are a card holder. You are not immune in X, Y, and Z. So I'm not necessarily sure that public place we even have to reference a car or not. The implication being if it doesn't reference it, then the immunity applies. I want to ask you about the state's request for kind of a do-over if we were to find that the statute does allow immunity in these circumstances. You argue that we should remand for a determination about whether there was recreational use going on or whether Mr. Tagge was could be prosecuted for DUI. In a case like this, to a trial to the court, you will agree, won't you, that it was the state's burden to offer all relevant evidence at the trial?
I agree, and I'm not suggesting that at the remand the state would be allowed to additionally present new evidence.
Okay. But also, wouldn't the state have to make the argument, wouldn't have to ask the court at the conclusion of the trial to find one way or the other based on the evidence? Here, there's nothing, the state made no reference in closing argument or in the pretrial statement to any of these issues.
Well, there is record of the state making the argument earlier than that when setting up the issue before the hearing starts.
Here before, in response to the motion to dismiss. After that, did it raise it?
I honestly can't remember off the top of my head exactly where it would be, but I do seem to recall somewhere in the actual hearing where the state makes this point, although admittedly it's not during the closing argument. I don't know, and the state's required to re-urge it at the time when the court only decides to rule on one of these theories.
I'm not following the distinction you're making with recreational use. Assuming you have a medical marijuana card, how are you ever going to be able to determine if the use is in the amount that's allowable with a card? How can you say that that's going to be recreational use because it's in a car? If someone needs to take medication and they take it in their car, it doesn't turn the medication into recreational use of medication. I'm not sure I buy that distinction, what you possibly gain by looking to try to define this as recreational use.
Well, the statute draws a distinction. In the actual immunity exclusion provision, it says in the final way you lose immunity that if you don't use it in accordance with the act. And then later on, there's a discussion of the presumption of medical use, and if you can rebut that presumption, then you lose your immunity.
What would you do to rebut that presumption?
I think you would have to show evidence like here that the use was for something other than medical use.
But how, if they've said we're going to be standing for 2 hours, we're going to take this to help alleviate any pain, what would the state present to rebut that?
I think that would be a jury or a trier of fact question where you'd present your evidence and the trier of fact, really the judge, since the judge determines immunity.
What would the state's evidence be that it's recreational use?
The state's evidence would be that the person subjectively didn't intend to use it for a medical purpose, but for a non-medical recreational purpose.
And here, the evidence would be
her
comment that it was a special occasion?
Yes, Your Honor.
We know, but we're not. I've got a detailed question. The way I read the record, each of the defendants was convicted of 2 crimes, use and possession, would all of our discussion here has been about immunity afforded to one who smokes marijuana. Does the state contend that the defendants were not immune for possessing marijuana?
I think that would be, it would have to be whatever the statute has. I don't actually have that provision in front of me. I think it would just come down to exactly the immunity afforded by the statute. If the statute doesn't afford immunity for possession, then there would be no immunity for possession.
All right, so we would have to vacate that conviction, those convictions at the very least, given 2802B.
You would agree that none of the considerations we're discussing today have anything to do with possession, right?
No, we're merely talking about the immunity granted under EMMA and whether the immunity applies or not. And so for these reasons, we respectfully request that the court affirm the convictions and sentences of the trial court. Thank you.
Well, just to make clear,
Oh, sorry.
I can give you a chance to respond. What I'm speaking of is in the immunity provision, because 362802 states that one is not immune for B, possessing or engaging in the medical use of marijuana on a school bus, in a prison, or in a school. So to distinguish the immunity that afforded to one who is smoking marijuana from one who is using or possessing it, that's the point I'm drawing.
Oh,
here.
I see. I think it would be an absurd result to say that you, if you're using it, could still be prosecuted for possession. So if you have immunity for using it, or you lose your immunity for using it, I think that would rise and fall on the same rules as the possession.
Well, I think the possession count was based on the 2 grams of marijuana found in the taggy's car.
Right. So since you have a broader right to possess than you have to smoke, only the use count would apply in the public place. The possession you are allowed to possess in a public place by the other.
Okay, so
statute.
You would agree that those should be vacated then?
Again, without the actual language of that part right in front of me, I wouldn't want to be completely sure, but if the immunity didn't apply, then yes, we would have to. But again, we obviously think that immunity doesn't apply. So,
understood. Thank
so
you.
for these reasons, again, we respectfully request the court affirm the convictions and sentences. Thank you.
Thank you.
I'd like to start with the rule of lenity. It is not, although it has been said to be a method of last resort. It's true that that was State v. Bond, 2014 Court of Appeals case, but in many other cases, State v. Anderson, State v. Barnett, both Court of Appeals, State v. Johnson, Court of Appeals, but from the Arizona Supreme Court just last year in Uridan, they adopted and applied the rule of lenity when, quote, the language of the statute is reasonably susceptible to 2 differing interpretations. And that's the ordinary statement of the test for the rule of lenity.
And what in particular are you suggesting is subject to 2 different interpretations? Which provision? The public place?
Yes.
Is subject to, and in your view, it is it's something other than this distinction between this is my personal land that is not a public place, as opposed to a land that anyone is free to enter, subject to conditions that might be imposed, whether it's a fee charged or something else. Is that not a clear distinction? Are you saying there's some sort of confusion with that definition?
Well, we've come up with 6 definitions of public place, and so I'm saying that term is ambiguous, but the definition you've proposed is the one from the California on Strider. And in Strider and in the California courts, any challenge, even an open gate onto private land, is enough to constitute a challenge that turns it from a public place into a non-public place. And they're talking about a gate into apartments. And then I want to talk about this.
I'm sorry, with a public parking lot here where anyone can just walk into it, you're saying there is a question about whether that's a public place.
If you didn't pay $10 to get into that parking lot, you had no lease or license to be in there. You could have been trespassed. Parking lots are not free for everybody to roam in. You'll be trespassed as a possible thief.
All right, when you go to a football game and they set up parking on practice fields. They charge $10 to park there, but people walk through there. It's on the way to get into the stadium. You're trespassing when you walk through that area to go into the football game?
If you stopped there, refused to leave, and they asked you to leave, the police would come and trespass
So
you.
you're not stopping there. And my question is, do you have immunity from smoking marijuana in that place? You've parked there. You paid your $10, or you haven't parked there. You're just walking through. Do you have immunity? Can you smoke marijuana as you're walking through that parking lot?
Absolutely not. This is Arizona. That's private land. If you go onto anybody's private land, anywhere in Arizona, you will be met with resistance.
This is a state university, public property. You're going to be. So you're saying it's just who owns the land turns it into public versus private?
Absolutely the same rules that apply to trespass would apply to your hypothetical. If you have a license to be there, and you need a license to be there, then it's not a public place.
So and in your view, then, it is okay to smoke marijuana at the public zoo, at the zoo that's a privately owned zoo but invites the public for a fee?
I'm out of time. Can I answer that?
Oh, certainly, yeah, we've continued a bit.
Yes, but as in the Maestas case, where the Court of Appeals observed that this isn't the end-all rule, that private zoo would almost certainly prevent you from smoking tobacco, let alone marijuana. And with that, I would ask that Mr. Tagge's convictions be reversed, as well as those of his wife. May I actually have 15 seconds to point to one thing in the record related to Elena Tagge?
Sure.
Twice in the record, pages 49 and 57, she told the police officers, according to the police officers, that she smoked marijuana because she had been in a car accident and that she suffered severe pain from that car accident. Just to know that, to put the special occasion thing into context. Thank you.
Thank you. Thank you to both or all of you for your written and oral arguments on this interesting case. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.